Y mina 37 nas legislatura in Guam is back from recess. Colleagues, we do have quorum. And before I start, I just, again, take the time to thank audio. I know that we've been having technical difficulties with the audio and with the mics, but now we're back, and we're going to go ahead and start this afternoon with bill number 240-37 COR, and the author of that is Speaker Therese Terlahi. So, Speaker, I will acknowledge you at this time to proceed. Consiga mo na po football.
Madam Speaker, I'm rising to make a motion to place Bill number 240-37 COR as amended by the Committee on Health, Land, Justice, and Culture to the third reading file. This is an act to amend section 34111B and to add a new sections 34401, 34402, and 34403 of Article 1, Chapter 34, Title 5, Guam Code annotated, relative to effectively distributing and disposing of undistributed child support funds at the Office of the Attorney General of Guam. I'd like to discuss that motion.
Yes, on that motion, I will go ahead and allow you to speak at this time. Please proceed.
So this bill, 240, was introduced in response to a request by the Office of the Attorney General of Guam to address a long-standing issue of theirs, which was undistributed child support funds. The bill aims to improve the legal framework that allows for distribution of undistributed funds and ensuring that they benefit the intended parties or support the Attorney General in its work, in its continued work to obtain child support for the children of Guam. The challenge that the Office of the Attorney General is facing in distributing these funds to either custodial or non-custodial parents has grown, resulting in significant amounts of money sitting in government accounts without benefiting anyone. The total as of December 31, 2023 was $6,003,735. So this bill would amend a section of Title 5, the Section 3411, to outline the process for managing these undistributed funds held for, in some cases, over 5 years. The Office of the Attorney General's Child Support Enforcement Division distributes these funds directly to custodial parents when they are located, or they refund them to non-custodial parents if the custodial parents cannot be found or are deceased. And with this bill, the children or heir of a parent can now make a claim to the funds, but if both parents cannot be located or are deceased, and it would then be up to the courts how to dispose of the funds. The bill allows the Attorney General to initiate the court proceedings to escheat these undistributed funds back to the government and to the Attorney General's office when no claimants can be located. It mandates a diligent search period above the current search period of 6 months before any escheatment process begins, ensuring that every effort is made to distribute these to the rightful parties. And these funds, if escheated back to the government, will go to the Office of the Attorney General's Child Support Division. This is, according to the Attorney General's Office discussions with the federal grant partners, pretty much the only place that it can go. We have, in the committee, explored different options of where this money can go, as can we give it to adult children, and this is, according to their grant partners, it can go back to the Attorney General's office, but that will reduce the amount of federal funding that the Attorney General receives in that grant period. But still, this is, at least it gets the money back to its original purpose and will enhance the capacity of that office to enforce child support laws efficiently. So the bill was amended in the committee because of those discussions and more accurately reflects, I believe, the amount of money that is actually in the fund and the process in detail of who's going to file, and the court's involvement as well. So I welcome any questions from my colleagues, and I urge them to pass this bill. This is, again, at the request of the Office of the Attorney General. Situs Masi, Madam Speaker.
Thank you very much, Speaker Terlai. Anyone wishing to speak? Senator Terlai, Taitagui, I will allow you to speak on the main motion. Please proceed.
Thank you, Madam Speaker. When I went to the public hearing on this legislation, one of the things that caught my ear was the fact that any escheatous funds that are given back to the Attorney General, that they would lose the possibility of receiving federal funds. In other words, it would just basically lessen the amount. So if they were to get $1 million from escheated funds, then whatever federal funding coming their way, that's $1 million, then they probably won't get it. It wasn't really elaborated clearly. I mean, I don't want to, the last person wants to lose any kind of federal funds or the opportunity to have it. So my question is to the author, if she should yield, whether these federal funds are talking about not being able to obtain from the Attorney General based on whatever escheatous funds is put into their account. Is this all federal funding that's coming in their direction, or is it just federal funding from, let's say, the courts? Some of the, if I'm not mistaken, there are different types of, like the Burns grants that are out there. Public Health has some grants that are out there. So that's my question, Madam Speaker.
Thank you, Senator Taitagui. Speaker Therese, would you like to yield to that question?
Sure. I don't know the exact name of this fund, but I believe it's a very specific to child support grant funding that they receive, and all jurisdictions receive part of this. And they're not connected with any other grant. This is pretty much just to run the programs, the child support. This is how our child support office is funded, through these grants, and it pays salaries and other things there. And so if there is any money, for example, the $6 million is cheated to the Attorney General's office, it can only be used in that division, the child support division, and then the grant funding that child support office is supposed to receive for that year will be reduced by $6 million. Yeah. And I guess they look at it like a similar purpose, similar source.
Yeah, which is...
Senator Taitagui.
Thank you, Madam Speaker. And thank you for that answer. It's very disappointing to hear, because it's, funds that never belonged to the federal government in the first place. And I know that they're there to assist, but as we all know, that even in the child support division, there are a lot of things that they need in that area, especially when it comes to processing or data or software that's used to track these individuals down. And it's costly to get this type of equipment at the Attorney General's office. To be able to find these individuals, the parents or the non-custodial parents, let alone it was even brought up that the money should go back to the child themselves. So is there still a possibility if any of these funds will go back to the child themselves, instead of, if there's not a custodial parent there or a non-custodial, both parents have passed away, is there any possibility that that funding can go directly to that child after the age of 18?
Thank you, Senator Taitagui. Speaker Therese, on that question.
Thank you for the question, and that is exactly the question that was raised at the public hearing by both myself and Senator San Augustine, and the Attorney General's office seemed to agree that we could try to give that money back to adult children, for example, instead of to their parents if they were not able to locate the parents. But in their correspondence with the Program Specialist, Region 9, Administration of Children and Families, they were denied that. They specifically asked them, can we do this? And the answer that came from Region 9 was no. all collections, including undistributed collections, have to be distributed to the family in accordance with 45 CFR 302.38, which states, quote, "The state plan shall provide that any payment required to be made under sections 302.32 and 302.51 to a family will be made directly to the resident parent, legal guardian, caretaker, relative, having custody of or responsibility for the child or children, judicially appointed conservator with a legal and fiduciary duty to the custodial parent and the child, or alternate caretaker designated in a record by the custodial parent. An alternate caretaker is a non-relative caretaker who is designated in a record by the custodial parent to take care of the children for a temporary time period." And the question presented to them was, can we, if we cannot locate parents to distribute the child support, can we distribute to the children directly? And the answer was no. So it's by the Code of Federal Regulations.
Senator Chadwick.
Thank you, Madam Speaker, and thank you to the author of the legislation to answer my question. And it just, boggles me. Why? Why not? This is not federal fund. This comes from the parent themselves. It doesn't make any sense why we are not able to do that. Why does Region 9 have jurisdiction over payments being made to the Attorney General's office? Maybe that's time for another legislation later on down the line, maybe. But I just don't see how they have jurisdiction over, the federal government would have jurisdiction over these payments. The other question, the last question I have is based on this legislation. There was also legislation that was introduced in 2013. It was Bill 28-32. This legislation was passed, and basically it has the direction of where this funding is also going to go. Now, I looked at both legislations and noticed that in certain sections of the law, where it talks about 34111, collections, accounting, and distributed of funds. And then I looked at the current legislation that's in front of us right now, and it's quite different. I mean, it's not underlined. So in my book, that means if it's underlined, it's included. It's an inclusion, brand new, but if it's not underlined, then it's the current law. So my question to the author is, what's the difference between, what changes this up from Bill 28-32 that was passed in 2013 based on this bill now?
Thank you, Senator Chadwick. Speaker Therese, there's a question. Would you like to have it answered? Do you want to answer that question as proffered by Senator Chadwick?
I believe the main difference is a more detailed procedure, and that in the past, the money can be escheated to the government of Guam, but that was never done because it's actually prohibited in the code of the CFR, the federal code. And so we are now making the statute amended to go back to the Attorney General's Office, Child Support Division. The other option that they did in this bill was they allow the court on Guam to make a decision as to whether, if a child has made a claim on those funds, for example, his parents have passed and his parents should have had those funds, the child can make a claim in the Guam court, and it would be up to the court whether they can distribute those funds to that child at that point. Adult children we're talking about.
Thank you, Speaker. Senator Chadwick, you still have the floor.
Thank you, Madam Speaker. According to the bill that was passed, 28-32, it indicates there on section 34111, the number 2, and it reads that the funds be deposited with the Treasurer of Guam in an interest-bearing account for a period of an additional and then it was 5 years was crossed out and 1 year was put into place. But when I look at this current legislation with no underlining, it's different. It says in that same section, 34111, section 2, if the custodial parent cannot be located or is deceased and the funds are owed to the custodial parent, OAG, CSED shall first refund such funds to the non-custodial parent. So it's two different languages. It doesn't change. It means that the bill that was passed in 2013 on that section reads differently compared to this bill, which is 3411 in section 2. So I'd like 1 minute to try and clarify this issue, okay?
I understand. Thank you. With that being said, I do have a couple of inquiries also. So I'm going to go ahead and call for a 1 minute, a moment's recess.
Colleagues, we're back from recess. Senator Tello, do you have anything to follow up? And we can move along to Vice Speaker who's going to speak.
Mr. Speaker, we were able to identify some issues in the legislation, and I think the Speaker, the author of the legislation, is going to make some corrections right now before we move forward. Thank you, Mr. Chair.
All right, thank you. Madam Vice Speaker, you have comments on the bill? Oh, Madam Speaker.
Yes, point of information, the retiree speaker is correct that the clean version as amended, the parts that are supposed to show deleted have already been cleaned, so it's too clean. It looks like an engrossed version, but if we could go back and refer to the marked up version, I would like to make that motion if I could be recognized to do that. The markup version shows the deletions of all the existing code language that need to be deleted as well.
All right. Yeah, if we can get the copies made so that everybody can have a copy in their hands. All right. So we'll have a quick recess while they get the copies. Quinn, thank you. My colleagues were returned from recess. Madam Vice Speaker, speak on the bill.
Si Jus Masi, Mr. Speaker. Mr. Speaker, before I pose my inquiry to the author, and I know that this bill was at the request of the Office of the Attorney General, I just want to make sure that some provisions are placed inclusive of the issues and concern that was noted by the retiring speaker, to making sure the child or the absent parent who was paying the child support have every means been exhausted. So my question to that, and it's not that I have any opposition to this bill, it's really important to know that the reason why there's child support is to make sure that the minor child gets that resources he needs from that non-custodial parent. So my question, and I did on the recess speak briefly to the author, and I do have a point of inquiry, and I hope she will yield to this. And of course, my main concern is that these fines go to the children who need it. I believe it may have been covered briefly in the opening of the author, but can we detail how a non-custodial parent gets notice of this process, and how many attempts to inform the parents that there are funds available but have not seen transferred for one reason or another, and what rights are to the children who have to recoup these funds before they are transferred away or goes into a treatment. So those are the three right now, and then I probably have a follow-up. So
Thank
we
you.
want to take it one by one.
Speaker Terlai, do you have like to yield to the question?
Mr. Speaker, as she's looking, I know she really is working on some of the answers, but I do want to share the example of what has happened in the past when the non-custodial parent and the parent who's supposed to be receiving the child support, the non-custodial parent may depart, and the address that has been provided has not been given or forwarded to the Office of the Attorney General. Henceforth, that every time notices are given, it's not being done. So one of my concerns were, what about public broadcasting, the way we do it with tax returns or what have you, where there's a list of non-custodial parents who've made payments to child support because they're not deadbeat parents, and for some reason or another, things get miscommunicated, or the addresses are changed, or employment is changed, numbers are changed, and what are the attempts being done? I know that in some of our other statute, there is a requirement to have electronic broadcasting out there, right? You have to post in the newspaper that these are tax returns, or these are bank accounts that haven't been that have been dormant for more than a year, or these are tax returns that have not been received to date. You have so many days to claim, and that is why I pose this question, because we have seen, or me personally, based on working with the Public Defender Service Corporation many years ago, decades ago, that cases like this have happened, where the non-custodial parent has been doing their job, and for some reason or another, things have come up, and then there's not a communication between the Office of the Attorney General, the custodial parent, and the non-custodial parent. So what measures are we taking into place? And again, as previously noted by the previous speaker, why is there a mechanism that could be utilized for us to create, notwithstanding that if the children become adults, or that besides having to go through court proceedings through probate or what have you, because probate is costly, what can be utilized to give that minor child who's turned an adult that, or even if they're still minor children, what measures are being done to date? Cesar Masi, Mr. Speaker.
Madam Speaker Therese, I'd like to answer you to the questions.
Thank you. I have been trying to find their exact words from the Attorney General so I don't misquote them, but I'm going to have to paraphrase and say this was raised at the public hearing. Of course, this is one of our largest concerns is we don't want them just to take that money for their office. If we can, we have to exhaust all our efforts to find the parents, either the parents who have been paying and no longer need to be paying for whatever reason, or those parents who should have been receiving and have not been receiving those funds. So that's, of course, the priority. And I believe that the Office of the Attorney General's Child Support Division is very strictly regulated by the federal funds that they receive, so they must report their efforts as well. And in the case of this bill, we have put in extra provisions for notice just in case. In other words, this is on top of, some of these have been 5 years, and so they did in their testimony talk about how they had gone back to all those cases and tried again to see if they could reconcile and give some of that money back, and they did. They were able, I think the amount was like $391,000 was distributed of the $6 million or more that they had at that time. So they have been working diligently. They said there's $823,000 they can't reconcile at all. In other words, I don't think they can even tell where it came from. That's what happened. But that's an exception. But going forward, all the money that they receive and is identified by payor or payee, meaning the caretaker of the child, then they have to use diligent efforts. And on top of all of that, we can't go through this process until the funds have been sitting for 5 years. We changed it from 2 to 5 years, so they have to make efforts for 5 years. And then on top of that, this is going to go through a proceeding filed by the Attorney General in the Court of Guam. So I believe that the court is also going to look at the same exact question that the Vice Speaker is raising, and that is, have we done everything we possibly could to get this money to that child? And the court is going to determine that according to the petition and the notices. And in addition, this law will now, or this bill, if it becomes law, will mandate an public notice before the funds are escheated, be published for 60 days in any daily newspaper of wide circulation once each week for 60 days, and on the AG's website and the Government of Guam's central website for 3 consecutive weeks during this 60-day period. In addition, the order must be posted for 4 consecutive weeks on the public bulletin boards in Hagåtña. And upon completion of the publication of such order, the court shall have full and complete jurisdiction over the undistributed funds, and any person, including children, making claims on that funds or estates, then the court will be able, hopefully, if justice needs to be done, to bring justice to that, or to send the funds back to the Government of Guam and Office of Attorney General Child Support Division. I hope that answers the question. Cesar Masi.
In part, Mr. Speaker, it brings to light some of the things that I inquired about, and what I really also wanted to do was I was going to say, what other outreach has the Office of the Attorney General conducted to exhaust every effort to give these child support monies to the children that are meant to aid? And I know that the previous speaker asked a similar question to that. And as I'm looking at the amended version, as includes all the strikes and the understrikes, I did see an inclusion, one moment please, that specifically says that if the,
Do you have a page number so we can just follow along?
well,
with you?
on the amended version that was, that shows the strike-throughs and the underlines on page 4, subsection 1, it was, there, the number 1 was deleted, that the funds be returned. It says if the custodial parent is located and the funds are owed to the custodial parent, then the Office of the Attorney General, CSED, shall distribute such funds to that custodial parent. But then it goes on to say 2 was also deleted, and this portion was added. If the custodial parent cannot be located or is deceased and the funds are owed to the custodial parents, then the OAG Child Support Enforcement Division shall first refund such funds to the non-custodial parent. That was one of my other concerns, because I want to make sure that the non-custodial parent who's been faithfully, he's not a deadbeat dad, has been paying for the child support, get his money back. And then it talked about the provisions, about what the AG needs to do. If the non-custodial parent cannot be located or deceased, the minor child or any surviving heir of the custodial parent can make it a claim for such funds. However, OAG CSED shall not distribute such funds to the minor child or children or any surviving heir unless there is an order of the court. And then if after diligent efforts by the Office of the Attorney General, CSED, has been determined that the custodial parent and non-custodial parent cannot be located or are both deceased and the minor child or children or any surviving heir have not made a claim of such funds, the OAG, which is the Office of the Attorney General Child Support Enforcement Division, shall escheat such funds to the government of Guam. Mr. Speaker, I wanted to make sure that those provisions are in, but I also wanted to make sure that there was a reporting mechanism, that a public recording or broadcasting system in place, because as the author noted, that based on the extra putting in the paper, putting it in electronic form, putting it in 3 places in the Ganya and 3 places where either the parent or non-custodial parent is, it gives them an opportunity for those who may know can say, hey, your brother or sister or relative has so-and-so and there's money there, go check it out with child support. And like I said, I understand the need for this bill. I understand the support for the Child Support Enforcement Division. I have no qualms there. I just want to make sure, Mr. Speaker, that that non-custodial parent who's been faithfully paying, who's not a deadbeat parent, be able to get the funds back if nothing else is, if we've exhausted every avenue we can. It's only fair. And if that is delineated here properly, then I have no problems with this bill. So again, I want to thank the author for this legislation, but also want to say that I did have major concerns, because I want to make sure that resources are given to the actual, to the children who deserve it, the child who deserves it, and if not, then it really should go back to that non-custodial parent who's been paying. So, Sizus Masi, Mr. Chair.
Thank you, Madam Vice. Senator Tom, you have comments or questions on Bill 1240?
Yes, Mr. Speaker. Perhaps are we discussing 240-37, or are we discussing?
That's correct.
Okay, but not the one with the committee markups?
Actually, both. You should have both. You should have the...
Okay, all right, okay.
But it comes down to the same bill.
All right. Thank you very much, sir. God bless you, Tina, but I can't agree. I think that once the money is paid by the non-custodial parent, the person subject to the order, I think I think that the property interest in that money vests in the children. So I don't think the non-custodial parent should ever get it back because it's not theirs. They're not receiving anything back. It's not theirs. It belongs to the children. And I mean, that's the thrust of, I think that's the thrust of child support orders. I'm looking at the bill that Senator Speaker Therese has brought forward. And, sir, I'm on page 5, and beginning with line 1, 2, and 3. This question's actually a softball for Speaker Terlahi. It says that the notice shall be published in any daily newspaper of wide circulation once each week and on the AG's website and the Government of Guam Central website for 3 consecutive weeks. Does the offerer of the bill agree that this notice provision meets the requirements of Guam Code Annotated and the Rules of Civil Procedure?
Madam Speaker, do you yield to the question, ma'am?
I don't know about the rules. I'm sure the attorneys would also have to comply with the rules in addition to whatever we put on them by statute. These are just our statutory requirements for them.
Okay, but yes, sir. Thank you very much for the answer, Mr. Speaker. If in fact these do not meet the requirements of the rules for civil procedure, have we then, and I'm not saying we can't do it by any means, I'm just saying, I'm just wanting to know whether or not Speaker Therese's opinion would be that this does meet constitutional muster and we are modifying notice provisions in the rules.
Senator Tom, is that another question?
Yes, I'm sorry. That was a question to Speaker Therese, just whether or not, I'm going to assume that it does meet the constitutional requirements for notice, but it also allows notice on the AG's website and GovGuam Central website.
All right. Madam Speaker, do you yield to that question?
Yes, as the speaker has indicated, this requirement that we are putting on them goes far and beyond the existing requirements and far and beyond their requirements pursuant to the grant that they are receiving and beyond the requirements, I believe, that we escheat other funds. It's just notice to the parties. In this case, we're putting notice out
Right.
for a longer period of time, more often, and because of this extra concern that we have that trying to get this money again to the best interest of that child, for the benefit of that child, if we can locate them.
Okay, thank you, Mr. Speaker. My question was just basically, does Speaker Terlahi believe that this meets constitutional muster? The next question I had was this. It says, shall be published in any daily newspaper, which frankly there aren't any anymore, and on the AG's website and the Government of Guam Central website. Does the Speaker believe that the two uses of the conjunction "and" can also be read disjunctively, so it could read any daily newspaper or the AG's website or the Government of Guam Central?
Madam Speaker?
I'll yield to that question. No, I do not believe the word "and" in this situation means "or." It's to be published in each of those, and we do, in the open government law, require the daily newspaper, wide circulation, and the Government of Guam Central website. Together in this bill, we have also added the AG's website.
Okay. Thank you, Mr. Speaker, and now Madam Speaker. Okay, if it's, okay, this is one that what is a daily newspaper? What for purposes of this bill, since essentially, well, the PDN doesn't publish anymore and the Post looks like it's on its last legs, do you think that the electronic versions meet this requirement?
Madam Speaker, do you yield to the question?
I did not think so. The electronic versions, we were mirroring this after the language in the open government law, but he's correct, we did not say written, but we did say publish in any daily newspaper. I have not gotten any indication about any newspaper being on its last legs. So as far as I'm concerned, we're still requiring this for open government. I'd like to continue to require this. The the goal is to get notice to as many people as possible. If we put it in a printed paper, it's going to get to every manamko and who receives a newspaper, every business. In addition, it will be printed electronically and get to a whole other set of people who only use electronic newspapers. So hopefully, it will meet its goal by hitting all of these.
Thank you, Madam Speaker. Thank you for the answer. I just would note that because it is in the record that we read and conjunctively and not disjunctively, that we may run into some serious problems here if we no longer have a newspaper of daily publication. So we need to think about that, and we might want to address our notice requirements in the future. Madam Speaker, the next question I have is, Guam Code Annotated Estates and Probate under Title 15 contains an actual five or six section provision on escheat and escheated estates. Did my friend Speaker Terlahi, did she have a chance to compare the escheat law, which is now in place, with this proposed modification of escheat?
Madam Speaker, do you yield to the question?
I would yield. I've looked at that law. However, the law that we're talking about here that exists today is an escheatment law very specific to child support funds. So the bill is very specifically amending the current law that only talks about escheatment of child support funds and not escheatment of any other funds to the government of Guam. So it's very specific, and the relevant part of the law to look at for today's purposes for this bill is the specific laws that were in place prior to today regarding escheatment of child support funds specifically.
And thank you, Madam Speaker, thank you for that answer. I would invite the proffer of the bill, my friend Senator Terlahi, to check 15 GCA 1201B, which specifically addresses monies escheating to the government of Guam. They are subject to the same charges and trusts as any other fund or tangible thing which escheats. There's going to be a conflict here. And I mean, we could import language that say notwithstanding. I know that we're very fond of that word here, but if we were just to say notwithstanding, then you might be able to squeeze that one through. I just wanted to bring that to my friend's attention. And then also, I'm on page 5 and lines 19 through 21. The court in the escheat proceeding shall distribute all monies remaining to the government of Guam. Any person who does not appear and make a claim as herein required shall be forever barred. Now, an infant by nature is incompetent frequently to act in governmental proceedings. Since the money belongs to the infant, and when I use infant, term of art, up to 18 years old, when we use the term infant, and I'm speaking of individuals under the age of 18, how can an infant perfect their right to these funds? Because they don't belong to the adults, of course, they belong to the child. So I'm a little worried about a person, an infant, not appearing, even though they're entitled to the money, and making a claim. Does my friend see any protection for the infant in this matter?
Madam Speaker, do you yield to the question?
I'm a little bit confused with this questioning, but I'll try to respond.
Okay.
Currently, we have specific law in Guam law regarding child support funds that have not been distributed, and how the government of Guam is allowed by our law and the code federal regulations to have that money returned to the government of Guam and the Office of the Attorney General. So this bill is making it very clear how that's going to happen. And we are putting in this bill extra protections for the payor and the payee and the children. We've added something that is really not existing, and that is that a child can make a claim. Because previously they could not. It either goes to the payer, the payee, or the government. And that was it. They were undistributed, escheated funds. And according to the child support, the federal entity that I cited earlier, I'm not sure if the speaker was in the room, but it's Region 9 of, where is it? Region 9 of Administration of Children and Families. They do not allow that, the distribution directly to a child. So we, by Guam law, are allowing the courts
To steal it.
to weigh in on in these particular circumstances. Otherwise, they do not allow that. They're very clear in their answer to the Attorney General, which has been provided and has been included in the committee report.
Madam Speaker, thank you. I'd like to thank my friend for that answer. I cannot agree with the answer, though, since an infant who has no guardian ad litem, for example, or a lackadaisical administrator of an estate may, by the lapse of time, lose, under this law, the money which is in the possession, constructive or otherwise, of the infant. So I would just, it's her bill, but I would just caution that a vulnerable portion of our population.
Point of information, Madam Speaker.
Please state your point of information,
Mrs.
Madam
Mossy.
Speaker.
Yes, there is no current interest for an infant or a child. It is the payor or the payee. We either get that money from the person paying child support to the person who's supposed to receive the child support, which is not the child. That's not our law. That's the federal law. The money goes to the caretaker of the child. That's the law. And so I just want to point that out to the previous speaker because I think he's misstating the federal law.
Thank you.
For the point of information, Senator Fisher.
Yes, ma'am. Thank you for the point of information. I would just, with respect, I would note that my friend Senator Terlahi has not done child support actions in the Superior Court. I think she would be surprised to discover.
Point of information, Madam Speaker, a point of privilege.
Please state.
Personal
I think
privilege?
that information, first of all, is irrelevant because I can speak on this bill whether I have experience or not, and for the speaker's information, of course I have experience, and it's irrelevant to this bill. The bill is very clear on its face. It clearly states the existing law is clear on its face. The amendments we are making are very clear. The Attorney General's testimony, his office, Attorney Ray Alagan, their testimony is very clear. The evidence submitted by the federal counterparts as to the grants that they are receiving and how the child support can be paid to payees or returned to payors, that's also very, very clear.
Thank you, Madam Speaker. Senator Fisher, you may continue.
Thank you for the point of privilege, ma'am. I think that just a cursory inquiry from just about anybody in the bar would reveal that, in fact, the child subject of the order has an interest in the money that accumulates, and unfortunately this bill just cuts it off, and that's my concern. I had another question, and I'm trying to figure out how this one works. This is on beginning on page 5, case closure and escheatment of undistributed funds, notice of custodial parent, etc. Subsection A says the Attorney General shall continue for at least 6 months doesn't say more than 6 months, it says for at least 6 months, and it doesn't describe how they must do it. And we're talking about locating the custodial parent or payee, and such efforts to locate shall be documented by the Attorney General. Madam Speaker, I would submit to you that a Attorney General may very well send a letter at the 5.5 month point, not receive a response, and perhaps that letter or attempt to locate did not meet notice requirements, whether it did or it didn't. So the 6 month period closes and they make no further attempt, and then 5 years pass and the Attorney General begins the process of closing the child support and seizing the money, evidently. This incentivizes the Office of the Attorney General to not be particularly enthusiastic, I suppose, in discovering the whereabouts of the individual. So I would just like to bring that to the attention of my friends here in the body on whether or not we will have an unintended consequence that would work to the detriment of the child. So I really don't have any other comments other than when an infant who has no other protection is entitled to, say, several thousands of dollars, I think that it is odd. I think that it is not wise to cut off the infant's right to their own money. Thank you very much, ma'am.
Thank you, Senator Fisher. On the bill, Bill number 240-37. Senator San Augustine, you are recognized.
Thank you, Madam Speaker. You know, I can understand the bill to a certain extent, but it just bothers me. GovGuam, we, this body, created the bill that created the child support in the AG's office. And then we're supposed to use the federal regulation to kind of like help us, guide us in how we're supposed to manage it. But it shouldn't be the rule of thumb is what they say is what we're going to do. It's our creation. It's not theirs. We can follow their guidance and what they ask, but it just amazed me because, you know, unfortunately, after this hearing, I know of one non-custodial parent called me up and says, "Senator, that bill was good." I said, "Why you say it's good?" Because I was sent a letter that I'm going to get refunded of a child support I was paying 30 plus years ago. I said, "Really? 30 years ago, all of a sudden now the AG's office is going to let you know and says, hey, we're going to give you back, we're going to refund you what you paid." I said, "And what happened to your child?" The child was always with me, but I just didn't want my kids going back and forth between my ex and me. But the AG's office have written to them or her, and said that we're going to refund you. You know, it's amazing, huh? You have a hearing, then all of a sudden there's money's going to flow back to the non-custodial. It's amazing. It's like, you know, we all have to admit, huh, that everybody that works, you have a Social Security card, you know, Social Security number. If you want to find somebody, track them on their Social Security. The Social Security number, you find them anywhere in the United States. You can find that non-custodial or custodial parent. And if there was just a little bit more effort on the AG side, if you know who the child is, more than likely they have a Social Security number, and you can track them down. Are they still on Guam? You can ask that question. And I know that the court will be able to help and says, yeah, we can track them. If they're still on Guam, they can track them down where they're working on Guam. Why? Because they would, by federal statute, when they're dealing in taxes, they can communicate with revenue and tax and track that person down. They'll know if they got property, if the child has property, or the non-custodial or custodial has property, and if they're paying their taxes and where they're at, what's their phone number. Only because I know this about revenue and tax, I used to work there. And that's how we trace people when I worked in criminal investigation branch. That's how we find people in Guam. And you know what? I don't know, 60 days? I'm just kind of 5 years, and if you exhaust 5 years, just remember what I said earlier. A non-custodial parent called me and said, that bill is good because they called me after 30 plus years that I'm getting a refund. I'm only looking at 5 years. That's telling me something. There's many parents out there, and there's kids out there. And I'll bet today, if their parent were paying child support, they would need that assistance. And for me to sit here and say, let's follow the federal regulations on how we distribute the money, or how the office that we created distributes the money that we force on non-custodial parents to pay, I think we need to relook that. Because, you know, when we go into budget, we're going to discuss the AG's budget and find out how much money they need. And if this is another source of money, and then at the same time, the grant's going to say, well, we're going to reduce the amount of money you get in the grant because you got some money. I don't think that was ever the intent. It's bad enough that I hear from my OFB directors that there are millions and millions of dollars in grants that we seem to be missing out because folks are not applying for it. But with that, that's the comment I wanted to make about this bill. Not saying I'm in support of it. I like it because it's bringing attention to it. But I just got some reservations on it, and I just want to make sure that that's stated. Thank you very much, Madam Speaker.
Thank you very much, Senator San Augustine. On the bill, Bill 240-37, remarks on the bill. Speaker Terlahi, you may close.
Thank you, Madam Speaker. I think I'm just going to begin the beginning. So we do have a child support office, child support division of the Attorney General's office, whose mission it is to collect child support and according to a federal program. And Guam decided years ago, back in 1996, to join in this federal program. And so that's when they amended our laws to make our laws consistent with this program. And it's like Medicaid. They make a state plan, and they make it so that Guam is consistent and will be eligible then for the grants, which have pretty much run our child support division for many, many years by funding. So it's a significant amount, way beyond the $6 million of escheated funds that might be returned to them. But the main point of this bill is that there is already existing law by previous legislators as to how the money that is not collected is going to be handled. They have not been able to handle that money because the law is deficient. It's not enough. So this bill, again, recommended by the Attorney General, and perhaps that's why it's seeing some resistance here, I'm not sure. But I believe that these child support attorneys work very hard to make sure that they are meeting the mandates of those grants, of our laws, together. Our laws are consistent with those mandates, except for this part about no one's been able to touch these funds that have been sitting there for years. And anyone who says this incentivizes the AG, maybe they weren't at the hearing, because we very clearly tried to question them as to what would this like expedite the return of the money to the government versus trying to get it to those children. It's become the opposite. The bill is very clear. They must make these efforts for 5 years. And then, when they file, if they want to escheat those funds, meaning they could not contact the payor and the payee, and I believe they told us they have to use, or they use the addresses that were previously given to them. I'm sure they've done other things because that's how they were able to return a little bit more of this money, 300-some thousand over the past year or two, that had been sitting for years, meaning previous attorneys were still unable to return it. But it's to nobody's benefit for the money to sit there. And if the money is escheated to the Office of the Attorney General, then they will use it in turn to continue to collect child support for the rest of the children of Guam. There is no we are trying to protect payors here. It's not even us, it's the federal government. They mandate that if you cannot get that money to the child, if the payee refuses it or for whatever reason, it's going to go back to the payor. And in this bill, that's very consistent. It says if the payee is passed away or cannot be located, they're going to refund that. That's exactly the Vice Speaker's concern. Will it be refunded to those people who had been paying and for some reason the money cannot get to the payee? This bill is very clear, it will be refunded. That's number one. If that person is also passed away, then the money, there's neither a payor nor the payee to receive the money. This bill opens up an opportunity for a child to make a claim in court and for the court to return that money to the Government of Guam Child Support, AG Child Support Division for future use. After 5 years and 6 months of additional notice. 6 months of notice on top of the 5 years meeting their state plan objectives, meeting their required notices in all their regular cases. 5 years of payors and payees also having the ability to go to the AG's Child Support Office and say, I'm still paying this money, I don't know where it's going, and to inquire. Or 5 years for the payee, meaning the caretaker of a child, to say, I've received no money for 5 years. So I don't think anybody's trying to pull a fast one on anyone. We're trying to clean up the laws so that we can actually make some movement. We are creating in here, for the first time, the ability of a child to make a claim to the court. It's the entire process of the escheatment of funds, in other words, before it goes back to the government of Guam, is protected by the courts. We've put it in there that they will decide whether the Attorney General made its diligent efforts for the last 5 years and 6 months or not. The court will decide whether that payor is truly deceased or not. The courts will decide if they didn't contact the payee and they should have looked at more records or whatever they want to require them to do. But that's why it's set up this way. And I believe it's good protection for all the parties. And we've got all different interests in this. Those who are paying, those who should be receiving, the children's interests, adult child, and all of it protected by a process that will be put in place if this bill is passed, a process that will be implemented in the court system and decisions made by the judges. So I believe that all parties will be protected. Don't forget there's a whole other side of child support, and that is for anyone who's on public assistance. It's part of our state plan that public assistance will be reimbursed by child support, meaning you're going to pay for any public assistance that the caretaker of your child has to get on through child support. So that's part of our state plan for public health and for the child support. So all of these things, this is a finesse of the current process, and I believe it brings actually more protections to the current process of saying it's been 2 years or 5 years, send the money back to the government of Guam. This actually puts in a lot more protections to all the parties involved and to the child who had no interest in this previously. So I'm asking again for my colleagues to assist the Attorney General's office in their more efficient collection of child support and the more efficient handling of the $6 million sitting in the bank for the last 4 years at least. I'm sorry, $4 million sitting in the bank for 5 years. 6 million current funds. This is to take care of all of these parties and the funds to make sure that they are moved because they're bringing no benefit to anyone. Sijus Masi, Madam Speaker.
Thank you very much, Speaker Terlahi. On the motion to place Bill number 240-37 as amended into the voting file, are there any objections? Hearing none, motion carries. We are now on resolution number 218-37 COR. Vice Speaker Tina Munoz-Barnes, you are recognized.
Thank you very much, Madam Speaker. Madam Speaker, resolution number 218-37 COR is introduced by Senator Dwayne St-Nicholas. He asked that we move that to the bottom of the agenda. Senator St-Nicholas apologizes, but he had a medical emergency he had to deal with.
Thank you very much, Vice Speaker. On the motion to move resolution number 218-37 to the bottom of the file, are there any objections? Hearing none, motion carries.
Okay, we're now on Bill number 109, which was moved down earlier this morning. So Bill number 109-37 LS. Senator Shelton, you are recognized.
Sijus Masi, Madam Speaker, I move to place Bill number 109-37, an act to add a new section 4124B3 and 4 to Chapter 4 of Title 17 Guam Code annotated relative to providing parity by creating an exemption for completing the full 75 hours of service learning requirement for graduating high school students in school year 23 to 24, and instead require the completion of 35 hours of service learning, and for graduating high school students in school year 24-25, and instead require the completion of 55 hours of service learning on the third reading file, and I ask for the opportunity to introduce the bill.
Please proceed.
Sijus Masi, Madam Speaker. Bill 109 is offered for consideration by a legislature in Guam at the request of the 34th Guam Youth Congress. Originally proposed and approved as Bill number 3 in the Youth Congress, Bill 109, if enacted into law, is intended to bring relief to high school seniors in school year 23-24 and 24-25 in the event they are unable to meet the 75-hour service learning requirement prior to graduation. Enacted in June 2005 as Public Law 28-41, the Service Learning Law for Guam Department of Education students was established with the vision of an adequate public education much broader than just the basic skills of reading, writing, and arithmetic. Through the Service Learning Law, GDOE is encouraged to offer students in grades K to 12 an opportunity to engage in courses that include community service-oriented activities. The law defines service learning to mean a method of instruction under which students learn and develop through the integration of active participation in thoughtfully organized service and standards-based curriculum. Activities that would be eligible under the service learning law must meet the needs of our community, be coordinated with an elementary school and/or secondary school, help foster civic responsibility, and be used to integrate and enhance the academic curriculum of the students, and to provide structured time for the students to reflect on their service experience. Without any real movement on Public Law 28-41, the law was amended in July 2009 through Public Law 30-53, mandating each student to complete 75 hours of service learning as a requirement for high school graduation. The new requirement became effective beginning with the 9th grade class in school year 2011 to 2012. Public Law 28-41 was and still is an opportunity for GDOE to help prepare students in practical ways for their lives outside of school and after graduation. Recognizing the complementary relationship between traditional curriculum and engagement beyond the classroom. However, fast forward to the height of COVID-19, post-pandemic recovery, and the powerful typhoon that devastated our community just a year ago, damaging billions of dollars worth of assets across residential, commercial, public, and military properties, the Guam Legislature passed 2 bills exempting DOE students from the full requirements of service learning. Public Law 35-83, enacted in April 2022, exempts all high school students enrolled during school year 1920 from the service learning law, and Public Law 36-96 in May 2022 provided the same authorization for high school graduates of school year 21-22 and 22-23. Today, and with the support of the 34th Youth Congress and members of the Guam Education Board, Bill 109 recognizes there may be students who were unable to physically participate in service learning activities during school year 2020-21, school year 21-22, which include graduating students from the class of 2024 and 2025 due to the pandemic restrictions. Accordingly, Bill 109 proposes that instead of requiring graduating seniors to complete the mandatory 75 hours of service learning, those in school year 23-24 would be required to complete 35 hours, and in school year 24-25, 55 hours. Madam Speaker, I want to thank Dr. Carmen Garrido, a school guidance counselor at Southern High School, for reaching out to our office earlier this month inquiring of the status of Bill 109 on behalf of her students. I committed to Dr. Garrido that although there may be some hesitation by some colleagues entertaining Bill 109, perhaps due to an assumption that everything is back to normal and all of our public school students should have had enough time to secure service learning activities, I would make another attempt at getting this bill on the session agenda, even at the 11th hour. With that, Madam Speaker, I ask our colleagues to consider the merits of Bill 109, which, if approved, will ensure high school seniors in school year 23-24 and 24-25 are not unduly penalized. By adopting this legislation, we as policymakers will be doing our part in finding a reasonable balance between fulfilling the objective of the service learning law and the extraordinary circumstances our youth and families have dealt with, particularly during these past few years. Sidus Masi, Madam Speaker, and I ask for our colleagues' support.
Sidus Masi, Senator Shelton, Majority Leader. Is there anyone who'd like to speak on the bill? On the bill, Senator Fisher, you're recognized.
Thank you. I might be stating the obvious here, but this is of limited impact. It's only, as I understand, it's only going to be in effect from 2023 through 2025. That is a question for my friend Senator Shelton.
Would the sponsor yield to the question?
I do, Madam Speaker. That is correct. It is only for this school year and the following school year for the students most impacted by the pandemic and typhoon.
Thank you very much. And Madam Speaker, just one other question. Does this in any way interfere with the provision of in-class instruction on, algebra, trig, all that kind of stuff?
Would the sponsor yield to the question?
Yes, I do, Madam Speaker. No, it does not interfere with in-class instruction. The point of service learning, as required by the public law, is to have students gain experience outside of the classroom.
Okay, thank you for that answer. I just, none of us want a bunch of high school students out there painting and picking up trash and so forth. We want them doing actual service learning, and I'll trust the schools to make sure that happens. Thank you very much.
Sidus Masi, Senator Fisher. On the bill, is there anyone else? Vice Speaker, you're recognized.
Thank you very much, Madam Speaker. Madam Speaker, when this bill first came to play by the Youth Congress, I literally had reservations for cutting down the hours of service. This proposed legislation that came into law many years ago was literally an attempt to give the opportunity for our students to have on-the-job training. And even with our office, right, we work closely with the Public Policy Institute, and then having interns to work here in the summer, giving them literally the opportunity to learn hands-on how the process, at least for the legislature, works, how to create policy and all that. Though the good author has said that this is from the Youth Congress, it's temporary. I don't have a problem with it. I will support the efforts and oblige to the Youth Congress's concern, especially since it's just limited. But I really think that in the efforts in listening to our predecessors, our colleagues who were here and voted unanimously for this bill, it was literally to give on-the-job training, 100% hands-on, so students could have the opportunity to see how it was to work in the government, to work in the private sector, to work in the villages, to work in nonprofits and all that, to see if they would kind of like that kind of job and look at the different job industries that were out there. So in that efforts, I was a big proponent for having it at least for a pay period. If I had my way, I'd literally have it for a summer program or a fall program. But, you know, I understand that students have other things to do, extracurricular activity after school and all that. But again, the intent was really great to give these students that job training. So I will support the efforts and thank the Youth Congress and, of course, the good oversight for proffering it for them. Sana Masi.
Sana Masi. On the bill, is there anyone else who'd like to be recognized on the bill? If not, then sponsor may close on the bill.
Sidhu Masi. Madam Speaker, I'd like to thank our colleagues for the discussion on the bill. And once again, I'd just like to state that this is a temporary exception that we're making for our students who have endured so much over the last few years with the pandemic, with the typhoon, along with their families. Some of them were unable to meet these service learning hours, and we'd like to give them a little bit of leeway as their peers in the Guam Youth Congress have seen fit, so that they're able to still complete all of their requirements and make it to graduation. So I appreciate everyone's efforts, especially as we're in the midst of graduation season, for us to be able to support our students during this time. Sidhu Masi. And I move to place it in the voting file.
On the motion to place to the voting file to the third reading, is there any objection? No objection. Seeing no objection, motion carries. We're going to recess until tomorrow at 8:30. Recess.